I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a multi-part lawcast discussing Regulation A+. The new Regulation A+ rules took effect on June 19, 2015. Tier 1 of Regulation A+ allows for a raise of up to $20 million in any 12-month period, and Tier 2 allows for a raise of up to $50 million in any 12-month period. Issuers may elect to proceed under either Tier 1 or Tier 2 for offerings of up to $20 million. Today, I am discussing the additional requirements as well as benefits for a Tier 2 issuer. Tier 2 offerings present a much-needed opportunity for smaller companies to go public without the added time and expense of state blue sky compliance, but with added investor qualifications. That is, and as I've mentioned many times previously, Tier 2 offerings preempt state law. In addition to the basic requirements that will apply to all Regulation A+ offerings, Tier 2 offerings will require audited financial statements, though, as I have noted previously, the state blue sky laws almost unilaterally require audited financial statements, so this federal distinction may not have a great deal of practical effect. Tier 2 offerings will also require ongoing reporting requirements, including the filing of an annual and semi-annual report and periodic reports for current information. Tier 2 offerings have a limitation on the amount of securities non-accredited investors can purchase. That limitation is no more than 10% of the greater of the investor's annual income or net worth. It is the obligation of the issuer to notify the investors of these limitations. Issuers may rely on the investor's representations as to accreditation and investment limits without any further verification. The ultimate benefit is that Tier 2 issuers that have used the S1 format for their 1A filing will be permitted to file a Form 8A to register under the Exchange Act and become subject to its reporting requirements. A Form 8A is a simple registration form used instead of a Form 10 for issuers that have already filed the substantive Form 10 information with the SEC. Upon filing a Form 8A, the issuer will become subject to the full Exchange Act reporting obligations, and the scaled-down Regulation A+ reporting will automatically be suspended. With the filing of a Form 8A, the issuer can apply to trade on a national exchange. When the securities will be listed on a national exchange, the accredited investor limitation will not apply. This marks a huge change and opportunity for companies that wish to go public directly and raise less than $50 million. Details determine diligence, so remember that an initial or direct public offering on Form S1 does not preempt state law. By choosing a Tier 2 Reg A+ offering followed by a Form 8A, the issuer can achieve the same result, i.e. become a fully reporting, trading public company without the added time and expense of complying with state blue sky laws. The other consideration being the added investor qualifications required in the Reg A+ offering. But if the issuer meets the requirements for and lists on a national exchange, those added investor qualifications no longer apply. Finally, effective July 10th, the OTCQB has amended their rules to allow a Tier 2 reporting entity to qualify to apply for and trade on the OTCQB. However, unless the issuer has filed a Form 8A or Form 10, they will not be considered subject to the reporting requirements of the Exchange Act for purposes of benefiting from the shorter 6-month Rule 144 holding period. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.